again it is a no in case of US, and India it is still bending. And there is one photographer called Ankit Sani, and he photographed some sunset from his home, and he combined this photograph with the like a painting of Vincent van Gogh. Actually, Vincent, he was a Dutch painter. He was in the slum in and during that days, and he was having some struggles, and he wants to express the simple lights in that struggle. Sky kind of painting he is making. He was expressing his human feeling with this picture. The picture is named as Starry Night. So he was what Ankit Sani is trying to do is he is combining his own image with the image of Vincent, and with using the Raghav AP painting app he was trying to create, and he has named it as a Suryast. Suryast means sunset. Okay, so Suryast, actually he is able to create it. But in US again it is getting rejected, because what the US is saying is you are combining the your picture with the picture of the others. First thing is that one, because you cannot combine the ideas of yours, even though the copyright it is should be only original, not the new novelty condition is not there. But the idea of the sterling and the colors are being incorporated in this. Okay. Apart from that, AI is not AI is mentioned as a co-author, so that is not practical in case of US. So it is got rejected, and whereas in India it is still bending. And okay, now whatever the AI intellectual, it cannot get IP. AI creativity also it cannot get IP. Can AI assisted creativity get IP rights? So this is similar to what I have done it in the previous slides. Like I'm giving each and every simple commands, and I'm trying to draw make a picture out of that. So that can also that can get IP. So that also cannot be accepted. Like for example, in case of Jaria of the Dawn, actually this was a comic. A comic of Christina Hastanova, who was the author of this, and she was a CS computer science expert, and she was using some mid journey to create the picture of this comic journals, and she was making some comic journals out of this. And while applying for the copyright, what the US is saying is, since the image is created in the mid journey, you will not be able to get the copyright for the images. But whereas the story is yours, and the placement of the pictures and placement of the pictures text in the particular book, it is yours. So the copyright will be given only for the for only for this story, as well as the placement of the pictures, not for the picture itself. So she got the partial copyright. Actually, again here the US court is saying that, since the output, whatever the argument of Christina is, like she was giving each and every command, like I have given some each and every command, I am able to create the picture. Similarly, she has given some each and every code. She was doing some code, and she was giving some command each and every small minute pieces of art also she was giving. And why it is not provided the copyright? What yours court is saying is, like see, whatever you have produced, it's an image, but the output of the image, it's not in your hand. Okay, so how the image will be coming, it is not in your hand. So that's why the copyright is not given, because it is the output of the AI, so it is not possible to give a copyright. So from these case studies, what we can understand is, AI as a owner or inventor, creator, then IP protection is not available. AI generated contents, again the IP protection is not available. AI as a tool for inventors or creator, it is partially yes or no. Okay, because if the idea is yours, the idea can be protected. Okay, protected by the natural person, but not by the not by the AI. Okay, so whatever the AI produces the output, that cannot be protected, but whatever the author or creator is doing, as producing from their intellectual, then that can be protected. So I have given like a partial yes, no. Okay. Whereas invention related to AI, yes. Okay. So AI, it is like if it is provided, it has a technical advancement, then the invention can be protected under the patent act as a patent act as well as the copyright act. The codes, whatever the codes you are writing, you can give it in the AI rights. And especially, I want to tell you that if you are using a tool for the inventions or creations, then you have to clearly mention at what instant, like what extent of AI has been used. Okay, if you are writing some programs, then it is better to give the programs a prompt. Whatever you are trying to give, you can create, you can give it, so that they can have some idea like what is the intellectual of the human being and what is the intellectual of the AI. What is the intelligent of AI, I can say. Okay, not the intellectual. So the production for AI is this one. Okay, now the production for AI is okay. Now we have some AI, and AI is getting trained. We are using some materials from the for this preparation of PPTs or for preparation of the classes. We are taking some contents from outside. So how it is being seen? It is being seen as a fair use. Okay, so I am using just only for the spreading of knowledge. For non-commercial purpose, I am just for incorporating some question papers or for incorporating some knowledge to the students. In court cases, I am taking some as a evidence. So in that cases, they are considering as a fair use. Okay, I can take the rights of the other IPs and I can reproduce it for my own use, or for the non-commercialized purpose, I can use it. But in case of AI, can the IP rights of others can be used for learning. Okay, so AI, it is using for training, for its own training, it is needs lot of data. It is trying to extract data from others. Okay, from other picture, like other contents from the internet, or some other sources also. So can this be considered as a legal one? Okay, so in case of actually Google and Oracle, actually this was a case where AI uh, training data is taken from this for the preparation, like Google was creating some Android, and Oracle was having this copyright of Java SE. And Android, what they are doing is, in Google, what they are doing is, they are taking some codes from the Oracle and attaching to the Android. Okay, this is not the exact case of the AI, but it is similar to AI training data. Okay, so what this and Google was trying to do is, Android, it's a new form of tool. Okay, it is a new form of invention while developing. Okay, so for the developers who are for the developers of the Android, they are familiar with the Java. So what they are doing is, for the transformation from Java to Android, they are taking some codes of that Oracle, and they are trying to implement it. And the Oracle actually sues the Google for its infringement, and for training, for making some infringement of data or code. Actually, what code says is, like they have gone through all the codes of the Android. They have told that whatever the content of the Java, they are not using for the output product, but they are using for the interface between the Java as well as the Android. So also, it is the training data is 0.04 percentage. So they are concluding that Google is not making any infringement on Oracle codes. Okay, so these are the main outcome of this judgment. They are saying that 0.04. So in case of these infringements, they are usually, they will be checking it whether it is with respect to some output, whether output similar to the other one. If it is similar, then certainly infringement cases will be there. But if it is output is different, but you are taking some codes which is like very very less when compared to the output, then that is allowed. That they are considering as a fair use. Whereas in case of an AI, the entire training data, it is not new. It is going to be taking entire data from outside. Okay, so in that cases, certainly the infringement cases will be coming into picture, because the 100% of the training data will be from outside. Okay, even if I'm taking for the for example, in case of a natural person, even if I'm going to take some picture, how many pictures I can take? I can take some one or up to 10 or 100 I can take, but not more than that. Okay, so it is, even with that one also I cannot incorporate all of these things. Okay, so and also it is not for commercialized purpose. Whereas in case of AI, initially while during training, it may be not in the commercial purpose, but after training, when it is getting implemented, then it becomes a commercial one. Okay, so there is a difference between these things. Okay, so if I'm putting my pictures from others and I'm selling it, then the infringement cases will be coming. Okay, similarly here also, while training, they are not taking any commercial things, so it is not going to get any infringement, but after that it is going to get the infringement. So training data with the unlicensed data, it's again infringement. Okay, so can AI infringe IP rights of others? Okay, so that one initially, the before slide is with respect to the IP rights of actually that is with respect to training data. Okay, so this one, it is after that one. Okay, so after that one, for example, in case of AI infringement, there is some cases with the Midjourney with Disney. Actually, Midjourney, what they are doing is they are taking the characters, they are producing some characters which is similar to the Disney. Okay, so this is the Midjourney output of Iota, and here Disney has this character, and Midjourney's output is also similar to that. Okay, so output here it is similar, whereas training itself, if you are taking a data, that is also infringement, and output is also, if it is similar, then it is causing an infringement. So one should be careful in utilizing this. Again, can AI mimic creators? So now AI is taking place of the creators. This is similar to some identity theft we are recently hearing in our daily newses. For example, Ilayaraja's pictures and voice, or SPB voice has been used in some the films. Okay, so AI can mimic the creators. Certainly, no. With certain permissions, they can do it. Without permissions, they cannot do it. Okay, so even if it is they are going to sing it in a new song. They are taking the SPB's voice, and they are going to sing different songs also. That is not permitted, because SPB's voice is identity, right? So AI cannot have a mimic of creators. So identity theft, it is not allowed. So protection from AI excludes AI as a owner, inventor, creator. Yeah, yes, actually, it is not a violation of IP law, because we are not including the AI as an inventor. Okay, whereas training data for unfair use, yes, we will be having some IP violations will be there. Infringement by AI, again, it is yes, and identity theft by AI is also IP law violations. Okay, so actually, now we have AI and IPR. Most of the things we are seeing yes or no. What is just opposite to AI. IPR is just against the AI. So in the future, if you see, like what are the questions we will be having is the IP infringement. Suppose if the IPR is having some separate law for AI for AI creators, or AI cases, or AI inventions in creators, for that, then there will be some cases will be related to this, and we have to take care of all these things. IP infringement, it can be direct by the direct companies also. Okay, while training data or giving output, it may be similar. After that, also someone is buying from them. Okay, then also the infringement cases will be going on. They may be unintentional, but it is they also need to face the infringement. So before that, buying some AI related things, you need to understand that the AI is fully protected from the IP violations or not. Okay, and uncertainty about the owner of the AI. So again, the inventor is not AI as an inventor, it is not acceptable as per the IPR. So there is a need of question like why the AI should not be inventor. So if AI is inventor, then there may be a separate part of the IPR. It should not be linked with the human inventors. Okay, so human intellectual, it is different from the AI intellectual. So there should be some separate boundary between those things. And even if you are restricting AI without any IPRs, then the promotion of the technology with those IPR AI will be suffering. Okay, so if it is not protected, then the field of AI will not grow. Okay, so that also needs to be taken care of. And I think it is. But so, like, how even though IPR as of now it is not supporting the AI, we have some uses of AI in IPR field. Okay, so we can do some IP searches. For example, in case of a trademark, the trademark, they are using the IP for making some searches. If you are having some trademarks, we can compare it with the trademarks available registered in that website, and then we can think whether it is a novel and whether it is a like applicable for registering everything. We can check it. Okay, after that we can do. So it is the AI is used in the searches, because nowadays the trademarks are whatever the IPs they are generating, it is very minute and it is very complex also to compare. Okay, for that AI is very much helpful. And AI application, like AI, IP application examinations. Actually, AI is trying nowadays. The controllers or examiners of trademarks, patents, and other IPs, they are using the IP AI for examining the applications. Okay, so it is increasing the speed of the outcome of the controllers, so that they can refer nowadays many more number of IP applications are coming, so it is easy for them for examinations. They are taking as a assistant from it. And apart from that, it is IP is creating knowledge generations. IP classification, like for example, if there is a design and copyright, it is more and more related. Okay, so if IP comes into picture, it is difficult to identify whether it is a copyright or whether it is a designs. Okay, in that cases the AI may help. Okay, so I'm saying it in the future terms. Okay, in the future, if you are taking a design, it will be registered in design as well as copyright. Then there should be a distinguishing between the copyright as well as the AI. So the IP classification will be very much possible in the AI. And for example, actually I have used some AI IP check for the prism experiment, prism picture, whether it is a new or not. And for that result also, it is giving, it is the IPR, like the prism with the application to the IPR, it is a new, it is providing. So I can conclude that my idea of concept of that prism is novel. Okay, so at the end of this session, I would like to say that as of now, IPR and AI are not on the same uh, but actually, as of now, the AI is seen as a IPR is keeping the AI out of the stage. And in future, we can say that IPR and AI will be interacting more, and we can have a separate section for AI also. And thanks for listening. In case of any doubt, you may ask. Any questions on these presentations? So with the AI, you should be careful enough, like how you are going to use the AI, in what way you are going to use AI for your inventions or for your creations, okay, and how far you are going to utilize the data available for your training of your AI, and based on that, go and apply for the IPR, any IPs, okay. So any doubt? Uh, Dr. Jayaraman. Dr. Jayaraman, do you have any doubt?
Dear participants, kindly share your views and questions in the chat box.
Hello, sir. I think there is no questions.
Ma'am, no, thank you, ma'am. Thank you for your informative session, ma'am.
Thank you, sir.
It is my privilege to propose the vote of thanks um, at the conclusion of FDP on intellectual property rights in academic session 4. Our sincere thanks to Dr. Amuda ma'am for delivering such an informative and thoughtful provoking session. We are also grateful to our management for their vision and continued motivation in organizing academic development program like this, which help us strengthen our teaching learning ecosystem. A special words of thanks to all the participants for your active engagement. Once again, I thank you all. Thank you, ma'am.
Thank you, sir.
Thank you, ma'am.